the time frame would be on getting the videos uploaded to YouTube. That's going to be next week sometime. I can't tell you if it's beginning or end, but next week. So if you need to avail yourself of the presentation for whatever purpose, you can do that on the internet, YouTube. I suspect it will be under, if you search under 7th Annual Harris County Public Defenders Free CLE or something like that, you'll be able to find it. I believe this auditorium houses about 600 people and 300 folks registered. There's a lot of empty seats, so what I'm going to tell you is this: we're having a little bit of hard time finding or hearing on the audio the questions that are coming in from the cheap seats. And I understand if you got a mean game of Candy Crush rolling in the cheap seats, it's okay. But if you're going to ask a question, if we can please do so in a way that we can hear it. And we're also going to try to repeat the questions for everyone's benefit and also for the benefit of people who are watching the video later. If you want to, I don't know, move up and be a little closer to us, you can do that too. If you don't want to, I completely understand. So without further ado, I'm going to introduce Miranda Meador. She works at my office, the Public Defender's Office, as an assistant. One of her skills that she has at the office and is renowned for it, and she's presented to our own employees on it, is preparing pretrial. Her trial files are typically the best in the office in terms of the investigation of the state's case, the activities of our investigators and the work product that they have going in her file, the tasks that she sends our investigators on, the records for mitigation and other purposes that she's gathered about the client. It's stellar. So she was invited to share some of these nuggets with you in her presentation, and that is pretrial investigation. Miranda Meador, please welcome her.
This talk is probably more geared towards newer lawyers. Some of it might be a little basic if you've been doing this a while, but hopefully it'll be a good refresher for even those of us who've been doing this for a few years. Can't hear me. Okay, can you hear me? Is that better? Okay. So this is basically things you can do online through investigators, through subpoenas, through records requests to help investigate a case and get your case ready for trial or pleas or dismissals. The district clerk site, so this one is really basic. You go in, you log in. However, it can be helpful. Some people don't realize there is a bookings and holds tab. So if you have family members who call and ask about holds, it'll show you what agency placed the hold, when the hold was placed, and if it's been lifted, when it was lifted. You can also go on the civil part and get civil filings. If you have cases where family law records might be helpful, you can get those. You can get images of your documents, of course. You can also link through the DA portal. If you're not using the DA portal, it has a lot of information. So you can only get to cases where you're the attorney of record, but once you're there, you can get summaries, the DA summaries, of all of your clients' priors. And so sometimes we go into cases and we're looking at priors, but we don't know what the facts are, what the DA thinks the facts are. This is what they have, and so it can be helpful to know what the facts of that, robbery he had a few years ago were when you're doing negotiations. It also can give you complainants and witnesses' names and phone numbers are on there if you need information to contact complainants and witnesses. Sometimes they'll upload files, 911 calls. Sometimes you can get offense reports or dash cam videos depending on the agency. Social media. So you should be looking up, I try to look up almost all of my clients on the main social media pages, if only to tell them to turn all of your settings to private or to suspend your Facebook page. Because what we can see, the DAs and their investigators, they can see. Complainants are also good to look up. For instance, this young man was a complainant in a case I had of an assault on a disabled person. My client had no criminal record. This was a felony. And he said, I didn't know he was disabled. The alleged disability was that he was deaf. And my client said, I had no reason to believe he was deaf. I just got in a fight with this guy. We were able to look up on his Facebook page, and you may not be able to see the smaller images, but probably 75% of his selfies, he's wearing headphones. So he either is not deaf or he goes to pains to make himself look like he's not deaf, which is important because there is an affirmative defense to an assault on a disabled person that the defendant did not know, and a reasonable person would not have known that the complainant had a disability. So we were able to use that and get him a deferred on a misdemeanor. Twitter, Instagram, things like Kik. I have accounts on a lot of these, if only to look up people on them. We also have investigators who will do that. Things like Kik and Snapchat are a little harder because they don't keep the records. They're supposed to disappear. But I've been able to look up complainants on Kik and find them, at least be able to communicate with them through those. Okay, subpoenas. At the beginning of probably 80% of my cases, I ask our admins to do a subpoena it's kind of an overall subpoena, and that's the wording on there. And so it's a lot of information. It goes to the arresting agency. You'll get your MDTs, your dispatch, body and dash camera recordings, and we also have this catch-all, all audio and video recordings. There have been more than one case that I've worked where we've sent this off, particularly to constables' offices. I'm not sure why it's the constables that do this, where in response to the subpoena, we get the 911 call, we get a copy of the offense report, we get our MDTs, and I also get a disc with recordings of interviews that they have done with the complainants and the witnesses. And it has happened in cases where there is no note in the offense report that these people have been interviewed. Maybe they haven't done their supplements yet, but I was able to get them before the DA even knew they existed, and we were able to listen to them. I took them to the jail, played them for my client. They were horrific, and we were able to do a quick plea for much less time than would have been offered had we waited and the DA's gotten a hold of those interviews and found out those witnesses existed. Okay, CPS. CPS records are helpful in pretty much every kiddie sex case, injury to a child cases, and all sorts of other cases. You want to get your client's records, complainant's records. If it's like a sex case, you want the complainant's siblings' records, the complainant's parents' records, anyone who's lived in their household for an extended period of time, their records. So when you do a subpoena, there's two different kinds of records. There's your entitled to records and the more protected records. Entitled to records, you'll get pretty quickly. Those are the ones involving your client. You'll get them, and the redactions will be things like social security numbers, other identifying information, and reporter information, which is protected under the family code. You'll get those quickly. If you want to get records you're not entitled to, those are the records where your client's not involved. The complainant's records, other than the case with your client's involved with, those siblings, the complainant's parents, those are protected. So the way to get those is you file your subpoena, and generally I file mine pretty broadly. I want any and all records, and if you want, you can email me or the PD's office, because there's certain wordings they have external files or certain wording you want to use for, and then I list the names and dates of birth of everybody I want. Then file a court order for the protected records, and that's kind of an example. That's when the CPS attorney will get involved. I happen to have done this a few times and have a really good working relationship with one of those attorneys. I think there are two now. And so I will file my subpoena and have it served on the last caseworker, and then I will email the subpoena and a copy of this motion directly to the CPS attorney, ask her when a date is good for her, contact the court, let them know when we'll be coming. You show up in court. The CPS attorneys who do this frequently understand what the deal is. They come in, they say, Judge, these are protected records, so if you're going to give them, we ask that you review them in camera, or if you're going to give them to the defense, that you sign a protective order. All but one time, the judges have found out how long those records are. They're hundreds, sometimes thousands of pages, and they say, okay, we'll give you a copy, because they don't want to have to review it. That's usually pretty simple. I've only had one time that a CPS attorney actually put up a fight, and it's because the regular attorney was out on leave, and she was a substitute, and I don't think she kind of understood this is the dance we do, and we just go and you kind of get what you want, and sometimes the CPS attorneys will even look through it and say, oh yeah, you need to have this. Okay, further into CPS. There was a time when I had some CPS records where the reporter information became very important. There were specific calls made to the CPS worker that is an injury to a child case, and my client is the boyfriend, that the mother of the child had told people, I am going to hurt my baby if I can't get rid of him. I can't handle him. I'm going to hurt him. So we needed to find out who that person was so that they could be interviewed and subpoenaed to come to trial. So I kind of made up a motion and I filed it ex parte and under seal, and I laid out for the judge, here is what is said on this page in the CPS records, and I need to know who this person is for investigative purposes, and then added in all of the constitutional clauses, due process and, right to a defense and all of that. And then took it to the court. I filed it under seal, so if you haven't filed something under seal, I put it in a manila envelope, I put that on the front, that this is an ex parte motion, it's been filed under seal, and only the clerk, the judge, and the defense lawyer can view it. I've never had a problem doing it that way. I went in front of the judge, he agreed, and then he ordered CPS, back up, CPS was at this when I approached the judge, he ordered then CPS to give me the reporter information, and it didn't take them very long. Okay, other things you can subpoena, calls for service. Sometimes you can get these without a subpoena. We have investigators that know some of the personnel at some of the different agencies, and they can just walk in and ask for it, which is really nice, because anytime you can get something without leaving a paper trail for the DA, like a subpoena, I'd do it that way. Calls for service can be interesting. Say you have, going back to kitty cases, you have a client where Dr. Lawrence or whoever it is that's going to show up for the state is going to testify as to behavioral changes that this child exhibited after the alleged abuse. If you can get calls for service showing runaway reports, family calling because the child has assaulted someone that go back before your client came in their life, it's a little harder to argue that those disciplinary issues are because they were abused by your client. School records, same thing. You can get discipline reports on those. You can get names of teachers to interview. The ARDs, which are for disabled students, again, if you have an issue with someone being disabled, like an injury to a disabled person or an sex assault of a disabled person, you can get school records. There are some different litigation when it comes to school records, but those, you're able to get those as long as they give the parent notice that they're being given. So if some lawyer, like sometimes these school districts will refer these out to civil firms and they don't know what they're doing. And they'll call you and tell you, we can't give you those because of the federal protection laws, FERPA, and you can tell them FERPA requires notice, not consent, and then usually that's pretty easy, and most of the judges, I think, know that a little better than the civil firms do. TDCJ records, you can get disciplinary records, you can get medical records you do through a release, so that's a little bit of a typo. You can get education records, which all of this can be used for mitigation or other investigative reasons. Juvenile probation records, if you have a young client or someone who's been certified, send that over. They are really good about getting those quickly. Juvenile probation records have a wealth of mitigation in them because the juvenile people do interviews with the parents. When juveniles come into the jails, they're given screenings and often more in-depth psychological and psychiatric evals that are in their probation records. So you can get a box of psychological evaluations talking about what kind of household the client grew up in, how many times they moved, how many different schools this kid went to, how many different apartments he lived in. And so I've done a grand jury packet where we used that and we mapped out how many different places this, I'll call him a kid, he's a teenager, had lived in the last 10 years. And it was something like 25 different apartments, and he'd been to 15 different schools, and it can be used for mitigation just to show he's never had any stability in his life. Work records are good to show if your client has worked, that they do work. I think some of the DAs think none of our clients ever work, and so that can be helpful. It can also be helpful for timeline purposes. If a certain offense was committed at a certain time, was your client at work or going to and from work? Okay, records request. So anytime you can get something without a subpoena, it goes a little more under the radar. Officers' personnel files. The first thing to do is to contact TCOL. They have, and I don't have it up there, but if you get with me, I'll give it to you. They have an email address. You simply send an email saying, I would like the records for, and you give the officer's name. Now, TCOL's not going to give you like disciplinary issues. That's not what they do, but they will give you their training records and they will give you their employment records. For training records, you know how when you go to trial, you get notice from the DA's office of all these police officers who are experts in every field, ballistics and blood spatter, and they know everything. It's good to know what kind of training they've actually had so you can use that. You might be able to challenge them if they start going into kind of getting out of their depth with different areas. Work records will let you know all the agencies they've worked in, and then you request their personnel files from those agencies. For instance, I was working a case, and I did this, and I noticed it was peculiar that this particular officer had been an assistant police chief out west, and then his next job was as a volunteer at a different police department. So then I did open records requests for his, I say, civil service and personnel records, and found out he had been fired because he had been arrested for, he held some woman naked in his apartment after a drunken night out. He was arrested. The case went away for him, but he was canned because he lied to the Texas Rangers during the investigation. So that was really helpful to have to use against his credibility when he testified. So then you can request the personnel records from the different agencies. It depends on what the agency is, where you send the request. For Houston PD, you send it to the city of Houston. For the sheriff's department, you send it to the sheriff's department. Those are our two main ones. The constable's office, usually you can get on their webpage and find who their public records person is. And just as simple, I'm requesting this. In my request, I say, I agree in advance to the redactions required by law, because it just makes it a little faster. They don't have to call you and say, I need to redact their home address, their social security number, their date of birth. And so I'll just say, I agree to those redactions, because those are required under the code, and that's fine. You can expect to get a letter from the agency saying they've sent off for an attorney general's opinion. They do this almost every time, and almost every time the attorney general sends them back a letter saying you have to give them the information. So if you get one of those letters, don't worry about it. It generally gets worked out. You can get old offense reports if you have enough information through the police departments, if you don't want to get it from the DAs. Military records can be helpful. Transcripts, any prior testimony on a case if you have a retrial. If you have a juvenile who's been certified, you should get the records. For one, to make sure that the certification went the way it's supposed to go. There are very specific requirements that the hearing's supposed to have and specific findings that are supposed to be done.